And good Saturday evening, and welcome to LawCall on WLOX and WDAM. All of our friends along the Gulf Coast and Hattiesburg. Hope you're having a good Saturday evening. We're here live in studio, and tonight's topic, something we all have in common. A dispute with your insurance. Jim Reeves, good to see you, my friend. Got kind of a family affair tonight. You got the whole crew in here.
That's right, absolutely.
Pretty much. Fighting the insurance company, something you kind of do on a day-to-day basis, isn't it?
Sure. So we handle injury claims and accident claims, and those almost always involve insurance companies.
Right.
And so, what we see a lot of these insurance claims are, people, quite frankly, being taken advantage of.
Right.
Most people have never handled an insurance claim or an injury claim. The adjuster who you're dealing with on the other side handles them every day.
Right.
And so there's a lack of basically a fairness in the proceeding to begin with, and they don't always necessarily have, and most of the time don't have, your best interest. Our old friend Matthew Lott from Pascagoula, the Lott Law Firm. He's a fantastic lawyer, knows a lot about the insurance.
A lot about the insurance.
He worked for years defending these guys, so he knows.
Right there.
So he knows it from the other side.
Matt, great to have you back on the show. The show began, and you brought up a really great point about the cap that is on recovery now for a lot of insurance claims. Kind of go over that, and the simple fact is here in the state of Mississippi, there's a roof, isn't there?
There is, on non-economic damages, and what that means is that if you don't have real economic losses, something that you can put on paper, then those are capped at $1 million. That's it. On medical malpractice claims, it's capped at $500,000.
And you were saying to me, $500,000 on medical malpractice, that could really make it tight on somebody going to court with it, can it?
That's right. And so if you're disabled or you're not working or something like that, then that's all you're going to get. And so some lawyers may not want to take that case because you're going to spend a lot of money to get there.
It literally, the finances might not work out on it for ever to go to court.
Well, no,
that's amazing.
They might not work out. They usually don't.
Jim.
And here's the intended effect, or what we were told about tort reform. We were going to have the case caps in place that would reduce insurance premiums. That's not been the case. What it effectively has done is meant that people, especially elderly people, children, people who don't earn a lot of money, typically don't get as much access now to the courtroom as they did before. Someone who doesn't earn a lot of money, doesn't have a lot of what we call economic damages, his claim by and large, especially in a medical malpractice context, is not going to justify the $100,000 to $200,000 an attorney has to spend in expenses just to get the case to court.
Right. Time for our email question of the week. Now, a lot of times we have people that just don't want to call in, so they email us, and we had that tonight from Lee. Lee asks, if someone causes a wreck while texting, does that automatically make it their fault? There's their first question for you, Jim. Here's the second part. Is there any way to prove the other driver was on the phone besides he said, she said? And as we talk about that, really could be he said, or she said, he said, or they said, we said. There's a lot of saids out there. All right, let's start with if you're texting and driving, does that automatically make it your fault?
First of all, don't text and drive.
Right.
It's a terrible thing to do. We all have the temptation to do it in this age where we have to be constantly in touch, but don't do it. Studies have shown it's as dangerous as drinking and driving. Just don't do it. But the short answer is no. It doesn't necessarily mean that person's responsible, but probably does mean that they have some responsibility. And here's why. In Mississippi, we have what is called comparative negligence, meaning this person could be texting and driving, and if somebody else ran a red light, they might both be responsible. So is that person responsible exclusively for it? Maybe, maybe not. Do they have some liability? Almost certainly.
Right.
It's just going to be different depending on the facts of the particular case.
Insurance companies, if you're involved with a disputed claim, they're checking your social media accounts, aren't they?
They are. And, as lawyers, we have to give advice. And one is, don't be putting stuff on social media, Facebook, Twitter, Snapchat, all that kind of stuff, where it's showing that you might be doing something you're not supposed to be doing. Or if it's a job-related claim that you're lifting something, that's related to that injured body part. So.
Jim, this is something that's just changed, hasn't it?
Yeah, and in the last 3-4 years, in terms of trials and preparing for trials and depositions, this is the area where the attorneys that defend the insurance companies have the most basically to cross-examine clients on, because they go on social media, they dig around, they look at things that maybe look inappropriate for somebody that's making a claim.
Right.
Maybe there's an explanation. Sometimes there's not. But I tell people when I represent them, stay out of social
Good
media.
evening, gentlemen. How are you all doing tonight?
Great.
Pretty well.
Okay, well, I was just calling because recently I've been getting a runaround from my insurance company.
Okay.
I recently made a claim about some property that was damaged, and now they just want to settle immediately. Should I wait it out, or should I get a lawyer, try to get a bigger settlement? What should I do?
Roger, appreciate the call tonight. Really do. That's a question I think a lot of people out there probably have on their mind. Matthew, Matt, what do you think?
Yeah, so property damage claims are a little bit tricky sometimes.
Yeah.
If you want to get estimates, you want to check it out. I mean, if it matches up to the estimates, you may or may want to take it at that point.
Right.
Obviously to fix the property, but if it's not matching up, you need to get it checked out by a lawyer.
Jim?
Yeah, and I say the rule of thumb generally in these cases, property cases less so, personal injury cases always, it doesn't hurt to pick up the phone and call an attorney that handles these kinds of cases. We don't charge for anything typically unless we recover, and so it doesn't cost anything other than a little bit of time. The problem is, especially less so in a property context, is you can look at blue book values and that sort of thing.
Sure.
But in personal injury context, you don't know the value of your claim because you probably never handled a claim
Hi,
before.
my name is Beverly, and I have been hurt on the job, and my problem was trying to find a workman comp doctor to go to.
Is your job telling you what doctor to go to, Beverly?
No, I had to go to the emergency room.
Okay.
And because it was urgent, and when I went there, I just had to get a regular doctor
Right.
to take care of my knees because it was necessary.
Okay.
But I never could get a workman comp doctor to find one.
I gotcha. Are you catching a little friction at work now, or is it going smoothly for you?
Well, they don't let me go now,
Okay.
and I still have this problem.
I gotcha. All right. Beverly, I hate to say it, we've heard this before. Let me throw it over to Matt, and sorry, I keep calling you. I got Matthew most of my life. So anyway, Matt, what are your thoughts?
Either way is fine. I answered it
Thank
better.
you, buddy.
So, so there's what's called a workers' comp fee schedule. I don't want to get too involved in that, but sometimes certain doctors don't want to meet the fee schedule, or they don't want to hassle with the insurance companies because it's a big hassle.
Right.
Okay. So that's just something they want to avoid. They may not want to take her claim.
Right.
From that aspect, but there's people out there.
Somebody to work through it.
There's plenty of doctors out there that'll do it, and that's exactly right. Some don't prefer to do it for various reasons. But there's plenty. So I would keep looking and looking. If you're not sure about this, again, same sort of rule applies. Generally, attorneys that handle workers' compensation claims handle them on a contingency basis.
Calling for somebody else. I have a question.
Okay.
That's just fine.
He got hurt on the job. He had a shoulder injury, and the doctor's fixing to release him. We're pretty sure to go back to work. But he has to do heavy lifting, so he's concerned about it. What happens if he goes back and re-injures it?
Gotcha, Dolores. All right. Matt, got to go quick on this one.
Yeah, that happens a lot as well, but you got to be careful and work within those restrictions. But if you get re-injured on the job, they're still liable for those benefits.
Still there. Okay.
Still there.
Right.
Jim?
Right. Well, typically, you should have gotten an assignment from your doctor if he's at maximum medical improvement that says these are his lifting limitations, and the employer should not ask him to do anything beyond that. If they do, then they're certainly responsible.
Would it be a new claim, Jim, if he gets re-injured, or does it stay the same?
Depends on the circumstances, whether it aggravated the existing injury or it's a brand new injury.
Dolores, take good notes on this one. I know that if you do have to go further with it, your attorneys would really appreciate that. It'll help you out in the long run. Appreciate everybody calling tonight. Matt Lott, thank you so much for coming in. Really do appreciate you driving all the way from Hattiesburg tonight. Jim, always a pleasure, my friend.
Likewise.
Next week, we're going to be talking about everything, anything. All topics are on the table next week, so give us a call if you couldn't give us a call tonight. But until then, good night.